opportunity to speak about protection in the process of the collection of data. After some general remarks, I want to try out to find the international legal basis for data protection or protection in the process of collection of data. Namely, I will talk really shortly about fundamental rights, and then I will especially deal with issues arising from the taxpayer as source of information and from third parties as source of information. I will conclude with some final thoughts. So first of all, I want to clear up what we are exactly talking about. What is the process of data collection? Well, I would say we're just talking about the transmission of tax-related data from the taxpayer, him or herself, or from third parties to the tax administrations. Has the tax administrations already gathered the information they need? We are not talking about data collection anymore, to my mind. We are already talking about use of data or further stages about exchange of information. And it is also obviously that there are different interests in this field of data collection. Of course, tax administrations do need the tax-relevant data to levy taxes accordingly and to ensure an effective taxation on a whole country or also on an international level. On the other hand, taxpayers may have concerns that the data may be misused and that it is not used the way it should. You're very welcome. So taxpayers may have concerns about the use of the data, and of course, since third parties now have to provide more and more information about other taxpayers for tax administrations, they might feel that this is a further burden. And if we look at the recent developments, it seems that the focus, especially at international level, lays on the protection of the tax base. So there is especially increase of exchange of information. There was the USGD G20 BEPS package, the EU anti-tax avoidance package, and so on. On the other hand, there are also some initiatives on taxpayer rights, especially some Bill of Rights or the Ombudsman. So, for instance, there are guidelines for a model for a European taxpayers codes from the European Union or a model taxpayer charter from 2013. However, all these Bill of Rights give only some guidelines or some programmatic rules for obligations and for rights of taxpayers and also for the tax administrations. But to my mind, it is not possible to receive any specific legal rights or protection rights from this Bill of Rights. So it's necessary to find another legal basis for the protection in the process of the collection of data. I don't want to talk about protection under national legal frameworks, for instance, the Austrian system. Instead, I want to focus on possible legal basis in the international law, namely fundamental rights. We have heard already about Article 8, the right to respect for private and family life, which also contains the right of data protection. Speaking about collection of data, the nemo tenitur in the ipsum accusare principle, which arises from Article 6, is also a really important fundamental right, the freedom from self-incrimination that may be relevant in the process of the collection of data. And also at EU level, there are lots of different provisions dealing with the right of protection of data, namely within Article 16 of the TFEU and the Charter of the Fundamental Rights of the European Union in Article 7 and then in Article 8, what we have already heard yesterday in more detail. Additionally, I want to mention Article 41 dealing with good administration and Article 14.2 that provides a right for access to documents, which may be relevant for protection in the process of the collection of data. At EU secondary law level, we have the Data Protection Directive and the General Data Protection Regulation of 2016, which give detailed provisions dealing also with the collection of data. However, all these fundamental rights are not absolute. So interferences are permitted. Basically, there are differences between the single rights. Basically, interferences are possible if there is a specific legal basis and legitimate object, and if it is proportional. So the question that has to be answered is already the collection of data protected by the fundamental right, especially the fundamental rights of data protection. When we're talking about tax-related data, we are of course talking about personal data in the sense of the right of data protection, since personal data shall mean any information relating to an identified or identifiable natural person. So data subjects are basically natural persons, at least within EU secondary law. Nevertheless, there would be room and discussions also if corporates and corporations may be protected by the fundamental rights of data protection, and I think there are really good reasons speaking for it. Speaking about tax-related data, we are normally not speaking about sensitive data according to Article 8 of the DPT, which would be personal data revealing racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union memberships, and so on. So if we are talking about sensitive data, which could be possible, for instance, for church taxes, then we have to keep in mind that a higher level of protection would be necessary. So I'm always talking about the fundamental right of data protection and so on, but the question is gathering of tax-related data already the processing of personal data? And of course, yes, it is. Since any operation which is performed upon personal data, such as collection and many other kinds of processing of data, are part of the processing of personal data. And it is already stated within the European Charter of Fundamental Rights and also within the DPT that such data must be processed fairly for specified purposes and on the basis of the consent of the person, consent or some other legitimate basis laid down by law. And so we see that here we have a restriction and a red line for the collection of data, that we at least have to have a determined legal basis. So having said this, I want to raise some issues if the taxpayer is the source of information. This can be the case within self-assessment, so that the taxpayer himself has to give the information to the tax authorities. In addition, it is also possible that further information have to be provided in the process of tax auditing. To my mind, one of the most important questions would be what kind of information may be requested by the tax authorities and how much information may be requested by the tax authorities. As I already have said, there are limitations by fundamental rules. So we need for precise provision in national legal systems. If it is so, it is also necessary that there is a public interest and that there is a proportionality, as it was already stated within the European Court of Human Justice. One word dealing to the legal basis, it is necessary that such provisions are in accordance with the law, meaning that first of all the measure should have some basis, and in addition it has to be accessible to the person concerned, who moreover have to be able to foresee its consequences for him. So we see it is not enough to just say something in national laws, it has to be determined in further ways. Well, so in sum, if information is needed for levying taxes accordingly, there should be no doubt that it is legal and no big deal if tax authorities require these informations. However, there are lots of gray areas. We already heard lots of transfer pricing documentations today and yesterday, especially also with public country-by-country reporting. But the question may be raised, of course, transfer pricing documentation as such is necessary, but is it really necessary to give each information that is required by tax authorities? For instance, is it really necessary that the number of employees have to be requested? Another question would be if data for mere statistic purposes may be used. We find a provision within Article 6 of the DPT where it is say that further processing of data for historical, statistical or scientific purposes shall not be considered as incompatible provided that member states provide appropriate safeguards. So we are here also dealing with the question, what are appropriate safeguards? And to my mind, we are also speaking about a kind of a proportionality question. Another question that may arise if the taxpayer is the source of information is if there is a right to refuse to supply the information. And to my mind, one of the most important legal protection tools would be the nemo tenetur in the ipsum accusare principle. So if the taxpayer have to give tax authorities some information also for tax purposes, but runs danger that there are criminal investigations afterwards, there should be basically the right to refuse. However, also this right is not limited, as the European Court of Human Rights has recently also stated within the decision in Van Wereld. In this case, the Dutch authorities they obtained some information from the German that Van Wereld had some interest in a Liechtenstein foundation, and they asked for more information about this foundation and the interests, but Van Wereld refused. So he had to pay high fees until he would provide the information. So he appealed and said it was not in line with the nemo tenetur in the ipsum accusare principle, and the Dutch High Court said this is absolutely right. He has to deal, or it has to be in line with the nemo tenetur in the ipsum accusare principle. So he has to offer the information, but the information may not be used other than for tax purposes. Nevertheless, Van Wereld didn't give the information to the tax authorities and appealed the European Court of Human Rights. And the European Court of Human Rights really stated that, of course, the freedom from self-incrimination would be important in this case, but since Van Wereld has overseen that the information he should give may only be used for tax purposes and not for criminal investigations, there was no problem with the freedom from incrimination, and at the end of the day he finally had to tell the information. So I now want to deal with some questions when third parties are sources of information, and we see in recent trends that more and more information has to be gathered from third parties, especially from financial institutions. So I want to raise some questions dealing with financial institutions. We can see that the relevance of bank secrecy has lost an importance. It also has lost importance in Austria, although Austria really has a long tradition of bank secrecy. So there are more and more breaches of the bank secrecy. So besides the suspicion of criminal offenses, tax violations, money laundering, there are now lots of breaches on the basis of international developments, such as on the level of the OECD and so on. All these breaches, of course, have to be in line with the fundamental rights as I have presented before. And I want to take as an example the Common Reporting Standard, since Common Reporting Standard is not only an exchange of information, but first of all a question of the collection of information. I want to think about it in more detail. Although within the Common Reporting Standard provisions, lots of information have to be provided by financial institutions, we're not talking about sensitive data due to Article 8 DPT. Nevertheless, the tax-related data is data in the sense of the right to data protection, and so we have to raise the question if we have a permitted infringement. So if a third party, the financial institute, have to give the information from the taxpayer to the tax authorities, the question raises, is this permitted against the background of fundamental rights? So first of all, we need a legal basis and sufficient determination. And as Ms. Wörer has yesterday presented in a great way, there are lots and really lots of different provisions dealing what information has to be given, when has the information to be given, and so on. So if especially EU countries or OECD countries has implemented the OECD Common Reporting Standard on the basis of the DAC or of the OECD models, there should be no doubt that there is a legal basis that should be appropriate. In addition, such infringement of the, or such a breach of the bank secrecy has to be in line with, or has to be in public interest, and it is arguable that, of course, the worldwide or the national taxation systems has to be ensured, so this would be also no big problem. The big question is if we are proportional. So if the Common Reporting Standard provisions are proportional. And the European Court of the ECJ is quite strict in this way. So he's saying it really has to be necessary, and there are similar decisions to the data retentions for criminal purposes. In this matter, the ECJ stated that it is not proportional because the data retention affects all persons using electronic communication services, but without the person whose data are retaining being, even indirectly, in a situation which is liable to give rise to criminal prosecutions. It therefore applies even to persons for whom there is no evidence capable of suggesting that their conduct might have a link, even an indirect or remote one, with serious crime. And moreover, it does not require any relationship between the data whose retention is provided for and the threat to public security. And in particular, it is not restricted to a retention or to restraints, so there were no restrictions. So the ECJ was really strict dealing with the data retention, and the question is if it is the same within the Common Reporting Standard. And there it has to be said that, of course, the data retention for criminal purposes and the Common Reporting Standard, they do have different aims. So the Common Reporting Standard wants to ensure worldwide effective taxation, and therefore it is arguable that there are, of course, two different things. On the other hand, it also has to be said that the provisions of the Common Reporting Standards in some ways are not that clear, since it is possible that some information has to be sent to countries that do not levy any tax, or that they, for instance, do not have a taxing right. Speaking about information that is gathered from financial institutions, also the questions have raised if there is a right of the taxpayer to be informed about the information. And speaking about the common reporting standard, there would be special provisions within the common reporting standard provisions that there have to be notifications. And there is also the right to be informed on the basis of Articles 10 to 12 of the DPT. However, there are some exemptions and restrictions within Article 13 DPT, so there is also no absolute right to be informed. And also dealing with financial institutes, we have already discussed it yesterday, is the question how to deal with stolen information or information that is not gathered on a legal basis. So we had the Liechtenstein Bank affair in 2008. Nevertheless, we see that there is more and more developments, and there are recent cases such as the Panama Papers, so this is really a hot topic. Of course, I think it's obvious that we are talking about the violation of the right of privacy. Nevertheless, the question raises whether there are justifications, and especially if there is a ban for the use of this stolen information. So the question is, may this information that is gathered illegally or in one step of the chain of information gathered illegally may be used for tax purposes. I think it is really important to differentiate if this information is gathered on their own initiative, or for example an employee of a financial institute, or on the initiative of tax administration initiatives. So for example, and cross example, if a tax administrative says to an employee, well, you know, this is the price for a CD with so much data information, I think there is of course a ban for the use of stolen information, and it is of course also not in line with the fundamental rights, and especially I'm talking about Article 6, the right of fair trial, and also the freedom from self-incrimination. But what is if the initiative was by the employee of the financial institute and the tax administration gains this information? Well, there were lots of arguments in favor for the use of the stolen data, and at the end of the day it was used. So there was an argument from France that tax authorities may collect data from third parties to the extent that they are unaware of the illegal source through which such information was acquired. And in addition, Germany argued that the information was not illegally obtained by tax authorities, and therefore they may use the information. The Constitutional Court Rheinland-Pfalz also stated that there was no interference into the core area of fundamental rights, especially Article 8 of the European Charter of Human Rights, since we are not talking about sensitive data, since we are not talking about the core area. However, there are also some arguments against the use of such stolen data, for instance, the rule of law or undermining of legal certainty. Also, the unity of the legal order would speak against a use of stolen data. And one argument that is, to my mind, one really crucial argument is that at the end of the day, there is support of criminals. So if employees know that there is a market for such stolen data, they maybe will continue to steal data, of course, illegally. Nevertheless, the data will be used. Same as with whistleblowing. If whistleblowers know that the data will be used, of course, they will keep on whistleblowing. Instead, so the question is, what would be proposed solutions? Instead, there should be an international framework of exchange of information, for instance, to ensure that there is no need for such information. I also want to point out that in line with such international frameworks, there must be more rights for taxpayers. So if we're talking about an international framework that ensures that the informations are really exchanged, and there would be no place for such stories as the Liechtenstein bank affair. It is also really important that taxpayer rights are in focus. So, to conclude, we have seen that within the recent developments, more and more information is requested from taxpayers and from third parties. On the other hand, there is a lack of further legal protection in return. We basically find legal protection in international law on the basis of fundamental rights. Especially, I'm speaking about the right of data protection and the freedom from self-incrimination. However, all these fundamental rights are no absolute rights. So if there is a legal basis and if it is appropriate, it is basically no protection for the taxpayer anymore. So therefore, matching or a more sophisticated legal protection of taxpayers in international law and especially also in national legal frameworks would be desirable. Thank you very much.